Hello everyone, I welcome you all to another episode of Courts This Week on Live Law, where we update you about all the important legal developments that took place all through last week. We will begin with developments from the Supreme Court and then cover High Courts and other subordinate courts. If you like our content, please do not forget to like and subscribe to our YouTube channel. The Supreme Court has issued notice to the state of Karnataka in a batch of appeals challenging the Karnataka High Court verdict that effectively upheld the ban on wearing hijab in government schools and colleges and listed the matter for further hearing on September 5th. During the hearing, when Solicitor General of India Tushar Mehta informed the bench of Justices Hemant Gupta and Sudhashna Dhulia that the petitioners have prayed for an adjournment of the hearing, the bench expressed displeasure at such a request. The bench had underscored that it will not permit forum shopping and accordingly declined the prayer for adjournment. The Supreme Court has issued notice to the Uttar Pradesh government in the petition filed by Kerala journalist Siddique Kappan challenging the rejection of his bail application in the Hathras conspiracy case by the Allahabad High Court. The bench comprising Chief Justice of India UU Lalit and Justice S. Ravinder Bhatt issued notice to the state government asking it to file its reply by September 5th. Pertinently, the Supreme Court made it clear that it will decide the matter and dispose it of on September 9th, which means that the bench will decide on September 9th whether to grant Kappan bail or not. The Supreme Court has refused to entertain a PIL seeking inquiry into the Rafale deal in light of certain reports in a French news portal alleging payment of bribe by Dassault Aviation to an Indian middleman. A bench comprising Chief Justice of India UU Lalit and Justice S. Ravinder Bhatt was considering a PIL filed by Advocate M.L. Sharma, which had made Prime Minister Narendra Modi a respondent in his personal capacity. The Supreme Court has refused to interfere with the interim order passed by the Jharkhand High Court granting interim bail to News 11 Bharat journalist Arup Chatterjee. While considering the plea filed by the state of Jharkhand against the High Court order, a bench comprising Justice D.Y. Chandrachud and Justice Hema Kohli were perturbed to prima facie note that there had been a blatant transgression by the officers of the State Enforcement Authority while making the arrest of the media journalist. The Supreme Court has refused to entertain a petition challenging certain provisions of the Special Marriage Act of 1954, which mandate parties to publish their private details open for public scrutiny before 30 days of the intended marriage. The Supreme Court during the proceedings inquired from the counsel for the petitioner, and I quote here, "Supposing we take up this challenge to these provisions in abstract at your instance and pronounce against you, would that bind everybody, including a person who may have a genuine grievance to raise?" Owing to this, the bench went ahead and dismissed the petition. The Supreme Court has dismissed a petition challenging Section 8 of the Rajasthan Compulsory Registration of Marriages Amendment Bill of 2021. The petitioner had challenged the law as it permits the registration of child marriages. While dismissing the plea, Justices Indira Banerjee and M.M. Sundaresh remarked that the bill is not an act as it is yet to receive the governor's assent. The Supreme Court Constitution Bench will start hearing in the cases challenging the constitutional validity of reservation for economically weaker sections and the reservation given to Muslims in Andhra Pradesh as a socially and economically backward class on September 13th and 14th. A 5-judge bench comprising Chief Justice of India UU Lalit, Justices Dinesh Maheshwari, S. Ravinder Bhatt, Bela M. Trivedi and J.B. Pardiwala decided to list these matters on September 6th to set the timeline for hearing and completion of other pre-hearing steps. The bench said that the hearing in these matters will commence from September 13th. The Supreme Court has closed the 2009 contempt of court case against Advocate Prashant Bhushan and Tehelka founder Tarun Tejpal in view of the explanation and the apology tendered by them respectively to the court. A bench comprising Justices Indira Banerjee, Surya Kant and M.M. Sundaresh closed the contempt proceedings in view of the explanation given by Bhushan and the apology expressed by Tejpal. Back in 2009, Bhushan had given an interview to Tehelka magazine in which he had alleged that 8 of the last 16 Chief Justices of India were corrupt. The Supreme Court has disposed of 10 petitions, including the ones filed by the National Human Rights Commission seeking proper investigation in the cases of violence during the 2002 Gujarat riots. A bench comprising CJI UU Lalit, Justices S. Ravinder Bhatt and J.B. Pardiwala disposed of the cases as infructuous after noting that the court-constituted SIT had already conducted investigation and prosecution of 9 cases related to the riots, and that trial in 8 of those cases have already been completed. A constitution bench of the Supreme Court is set to start hearing a batch of petitions challenging the constitutional validity and the practice of polygamy and nikah halala allowed by Muslim personal law in the second week of October after the Dussehra holidays. 8 petitions have been filed challenging these practices before a bench comprising Justices Indira Banerjee, Hemant Gupta, Surya Kant, M.M. Sundaresh and Sudhanshu Dhulia. The Supreme Court of India has closed the contempt proceedings pending in relation to the demolition of Babri Masjid in 1992. The contempt petition was filed by one Muhammad Aslam Bhure in 1992 against the state of Uttar Pradesh for violation of the undertaking given to the court at that time regarding maintenance of law and order in the area. A bench comprising Justices Sanjay Kishan Kaul, Abhay A.S. Oka and Vikram Nath closed the contempt case after taking note of the passage of time and the 2019 verdict of the Supreme Court that had allowed the construction of Ram Mandir at the place of the demolished mosque. In a significant judgment passed last week, the Supreme Court has held that arbitrators do not have the power to unilaterally fix their fees without the consent of the parties. The court held that the fee scale prescribed under the 4th schedule of the Arbitration and Conciliation Act of 1996 is not mandatory. The bench comprising Justices D.Y. Chandrachud, Sanjeev Khan and Surya Kant was considering the issue regarding the mandatory nature of the model fee scale for arbitrators prescribed under the 4th schedule of the Arbitration and Conciliation Act. In a plea challenging the delimitation exercise undertaken in the Union Territory of Jammu and Kashmir, pursuant to the notifications of 2020, 2021 and 2022, the Supreme Court has reprimanded the centre for not filing the countered affidavit even after it was granted 6 weeks' time to do so. The Supreme Court indicated that it is not imposing cost only because a young lawyer was appearing for the union government and had assured the court that the counter affidavit would be filed within a week. However, it was abundantly made clear that if the counter affidavit is not filed within the time sought, an amount of Rs 25,000 had to be deposited with the registry before the court takes the matter on record again. In a plea seeking directions to stop attacks against Christian priests and Christian institutions across the country, the Supreme Court has directed the Union Ministry of Home Affairs to obtain verification reports from 8 states, namely Bihar, Haryana, Chhattisgarh, Jharkhand, Orissa, Karnataka, Madhya Pradesh and Uttar Pradesh on the steps taken by their respective law enforcement agencies with respect to the alleged violence. The Supreme Court was of the view that the collated reports would help them in forming an opinion on the state's compliance with the directions issued in the judgment of Tehsin Poonawalla versus the Union of India. In a significant development, the Supreme Court has granted interim bail to social activist Teesta Setalvad, who was under custody since June 26 over the alleged fabrication of documents to file cases in relation to the 2002 Gujarat riots. She has been asked to surrender her passport till the matter is considered by the Gujarat High Court. The order was passed by a bench comprising Chief Justice of India UU Lalit and Justices S. Ravinder Bhatt and Sudhanshu Dhulia after Setalvad moved the Supreme Court against a Gujarat High Court order which had given a long adjournment in Setalvad's bail plea while not passing any order of interim bail. The Supreme Court has made it abundantly clear that it is not inclined to allow the petition filed by Suvenendu Adhikari seeking transfer of the election petition filed by West Bengal Chief Minister Mamata Banerjee out of the state of West Bengal. The Supreme Court opined that it cannot allow this choice of high courts. A bench comprising Justices D.Y. Chandrachud and Hima Kohli noted in the order that Adhikari seeks to withdraw the transfer petition. It also granted liberty to him to approach the concerned judge of the Calcutta High Court presiding over the trial of the election petition as and when the need arises to seek appropriate directions for orderly conduct of the trial. The Supreme Court has refused to entertain a PIL filed for the arrest of Syed Wasim Rizvi alias Jitendra Tyagi and Yati Narasinghanand in relation to the Haridwar Dharam Sansad hate speech cases. The court stated that the petition for criminal prosecution cannot be filed under Article 32 of the Constitution of India. The Supreme Court has allowed an NGO named We the Citizens to approach the union government with a plea seeking probe into the targeted killings of Kashmiri Pandits and Sikhs in Jammu and Kashmir back in 1990, which led to the exodus from the valley. A bench comprising Justices B.R. Gawai and C.T. Ravi Kumar expressed disinclination to entertain the matter and instead asked the petitioner to approach the central government and raise its grievance before the government. A writ petition filed by Rajya Sabha MP Dr. Subramaniam Swamy seeking to delete the words socialism and secularism from the preamble of the Constitution came up for consideration before the Supreme Court. A bench comprising Justices Indira Banerjee and M.M. Sundaresh posted the petition along with a similar petition which is listed before the bench of Chief Justice of India on September 23rd. The petition challenges the validity of the insertion of the words socialism and secularism in the preamble through the 42nd Constitution Amendment back in 1976 during the tenure of Prime Minister Indira Gandhi. The Delhi High Court has set aside a 2015 arbitral award directing Antrix Corporation Limited, the commercial and marketing arm of ISRO, to pay $562.2 million to Devas Multimedia Private Limited over the wrongful repudiation of contract. The Delhi High Court has said that the arbitral award suffered from patent illegalities and fraud and was also in conflict with the public policy of India. The Delhi High Court has observed that copyright infringers cannot be permitted to seek shelter under the messaging platform Telegram's policies merely on the ground that its physical server is in Singapore. Justice Pratibha Singh added that Indian courts can be perfectly justified in directing Telegram to run its massive operations in India to adhere to Indian law and orders passed by them for disclosure of important information relating to the alleged infringers. In the ongoing hearing before the Allahabad High Court in connection with the Kashi Vishwanath Temple Ganvapi Mosque dispute, the High Court has called for the affidavit filed by the state government and the central government sketchy and further directed the Additional Secretary of the UP government to file his personal affidavit in the matter within a period of 10 days. Terming the matter as national importance, the bench of Justice Prakash Padya directed the Director General of ASI New Delhi to file his personal affidavit in the matter within the same period, that is 10 days. The Allahabad High Court has sought a trial progress report in the Hathras gang rape and murder case from the CBI. A status report has also been requisitioned from the trial court through the District Judge of Hathras to ascertain the status of trial before the next date of hearing, that is September 20th. The Kerala High Court has dismissed the plea moved by the Principal District and Sessions Judge of Kozhikode challenging his transfer order to the post of Presiding Officer of Labour Court, Kollam. The transfer was made after the judge made the controversial sexually provocative dress remark in the order granting bail to Civic Chandran in a sexual harassment case. Justice Anu Sivaraman observed that the petitioner, who is a member of the higher judicial service, cannot be said to be prejudiced in any manner for his posting as the presiding officer of the concerned Labour Court, which is a post born from the cadre of District Judge. The Madras High Court has set aside the order of a single judge restoring the status quo ante in the AIDMK party as on 23rd June. The bench of Justice M. Duriaswamy and Justice Sundar Mohan passed the orders allowing an appeal preferred by Palaniswamy. In this particular case, the appellants had contended that the order of the single judge was beyond the reach of law and virtually sets aside the order of the Supreme Court. It was also submitted that the General Council meeting held on July 11th, whereby a resolution was passed for the expulsion of Paneerselvam from the primary membership of the party and from his post as the treasurer, was conducted after following due process. Thank you. Keep watching Courts This Week on Live Law for more such updates. See you next week.
Subscribe to our channel and press the bell icon to never miss a video from Live Law.